Hi, welcome. I'm Gregory Vadas, Chief of the FCC's Office of Intergovernmental Affairs. This is our fourth year of providing webinars aimed specifically at areas where FCC policy or rules directly impact states and local governments. We hope you find these events useful and welcome your feedback today, as well as suggestions on future topics you would like to be briefed on. Before we start today, I want to briefly speak to you about my office and hopefully your go-to office at the FCC, the Office of Intergovernmental Affairs. In short, the Office of Intergovernmental Affairs works to promote increased cooperation and coordination to enhance federal, state, and federal municipal relationships. Our office also serves as the FCC's point of contact for state and local governments and other governmental entities seeking information from the FCC. To accomplish our goals, among other things, we maintain ongoing contacts with organizations that represent state and local governments, attend and participate in meetings and conferences, seminars, and other gatherings hosted by organizations that represent state and local governments. And we just try to maintain relationships and ongoing dialogue throughout the year with you guys. Now, for today's program, I'm very pleased to bring you information about three proceedings at the Commission that directly impact your jurisdictions. Acceleration of broadband deployment by improving wireless facility siting policies, E-rate modernization, and technology transitions. And finally, some procedural details before we begin. We encourage you to register for the webinar via WebEx so we can capture your email for our listserv where we regularly send out updates about matters that the FCC that specifically impact states and localities. Information about how to register can be found at www.fcc.gov/events. Also, if you go to the FCC's homepage, there's a link to the events page. And we also have a phone bridge today for those who just want to call in and listen, or if your audio is not good. I think the number was changed on that, and it's 888-858-2144, and the access code is 892-6297. And finally, but not least important, very important, you could email us questions today at livequestions@fcc.gov, or you could send them to FCC Live hashtag on Twitter. And if you are viewing via WebEx and you encounter any difficulties, you could also view the webcast at fcc.gov/live. Okay, I think that covers all the housekeeping for today. And without further ado, I bring you Peter Trachtenberg to talk about improving wireless facility siting policies. Peter's the Deputy Division Chief of the Spectrum and Competition Policy Division at the FCC's Wireless Telecommunications Bureau, and we're very lucky to have him today. I know a lot of states and localities have expressed specific interest in this proceeding, and it's definitely going to impact all of your jurisdictions. Thanks, Peter.
Thank you. This presentation provides an overview of the measures that the Commission adopted in the Wireless Infrastructure Report and Order. To understand these measures in more detail, I'd encourage you to review both the rules and the text of the order. The order addresses 5 areas of regulation regarding the siting of wireless infrastructure with the goal of expediting the deployment of wireless services and capacity consistent with the law and the public interest. In particular, the order 1 adopts rules to clarify and enforce the requirements of Section 6409A of the Middle Class Tax Relief and Job Creation Act of 2012, sometimes referred to as the Spectrum Act. 2 clarifies certain issues regarding the application of the Commission's 2009 declaratory ruling, sometimes called the shot clock order, that established presumptively reasonable time frames under Section 332C7 of the Communications Act for local review of personal wireless service facility siting applications. 3 adopts measures that refine the Commission's process under NEPA for reviewing the effects of proposed deployments on the environment, including new exclusions and clarifications of existing exclusions. 4 again adopts new exclusions and clarifies existing exclusions that apply to the Commission's review of effects on historic properties under Section 106 of the National Historic Preservation Act. And 5, exempts certain proposed temporary towers from the Commission's process for inviting public input regarding the environmental effects of proposed registered towers. I'll turn first to Section 6409A of the Spectrum Act. Section 6409A provides that a state or local government may not deny and shall approve any eligible facilities request for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such tower or base station. The provision defines eligible facilities request as encompassing the co-location, removal, or replacement of transmission equipment, but does not otherwise define its terms. The order first adopts definitions for many of the terms that were left undefined by the statute. Addressing what constitutes an existing wireless tower or base station, the order defines towers as those structures built for the sole or primary purpose of supporting any commission-licensed or authorized antennas and associated facilities, including but not limited to those for private, broadcast, and public safety services, as well as unlicensed and fixed wireless services. A base station includes any structure other than a tower that at the time the relevant application is filed supports or houses equipment that enables commission-licensed or authorized wireless communications between user equipment and a communications network. In other words, it does not encompass structures such as utility poles or buildings unless those structures already support or house base station equipment at the time of the application. Further, to be considered existing at the time of the application, the relevant tower or base station must have been reviewed and approved under the applicable zoning or siting process or under another state or local regulatory review process, except that a tower that has not been reviewed and approved because it was not in a zoned area when constructed is still considered existing for purposes of Section 6409A. The order also establishes 6 objective criteria for determining whether a modification substantially changes the physical dimensions of a wireless tower or base station. More specifically, a substantial change occurs if a modification meets any of these 6 criteria. 1, for towers outside of public rights-of-way, it increases the height by more than 10% or 20 feet, whichever is greater. Or for towers in the rights-of-way and for all base stations, it increases the height by more than 10% or 10 feet, whichever is greater. 2, for towers outside of public rights-of-way, it protrudes from the edge of the tower more than 20 feet or the width of the tower structure at the level of the appurtenance. Or for towers in the rights-of-way and for all base stations, it protrudes from the edge of the structure more than 6 feet. 3, it involves installation of more than the standard number of new equipment cabinets for the technology involved, not to exceed 4 cabinets. 4, it entails any excavation or deployment outside the current site of the tower or base station. 5, it would defeat the existing concealment elements of the tower or base station. Or 6, it does not comply with conditions associated with the prior approval of the tower or base station unless the non-compliance is due to an increase in height, increase in width, addition of cabinets, or new excavation that does not exceed the corresponding substantial change threshold. The order also establishes certain procedural rules for Section 6409 applications. Specifically, the order limits documentation that a state or local authority may require to what is reasonably related to determining whether the application meets the requirements of Section 6409A. It also provides that covered applications must be approved within 60 days, subject to tolling by agreement or in cases of incomplete applications. With regard to remedies, the order provides that an application filed under Section 6409A is deemed granted if a state or local government fails to act on it within the requisite time period, but that the deemed grant will not be effective until the applicant notifies the governing authority in writing that the application is deemed granted. The order also provides that parties may bring disputes, including state or local challenges to deemed grant notices, in any court of competent jurisdiction, but provides that parties may not bring such disputes to the Commission. And finally, the order clarifies that Section 6409A applies only to state and local governments acting in their role as land use regulators and does not apply to such entities acting in their proprietary capacities. Turning to Section 332C7 of the Communications Act, this provision provides in part that state or local governments must act on applications for construction or modification of personal wireless service facilities, including both co-locations and new communications towers, within a reasonable period of time. In the 2009 shot clock order, the Commission determined that a presumptively reasonable period of time is 90 days for co-locations and 150 days for other applications. It also provided that a state or local government can toll the running of this period if it provides the applicant notice within 30 days of submission that the application is incomplete. The 2014 order provides a number of clarifications of the shot clock order. First, it clarifies the process by which the clock may be tolled when an application is incomplete. It provides that to toll the clock, a notice of incompleteness should specifically delineate all missing information and specify the code provision, ordinance, application instruction, or otherwise publicly stated procedure that requires the information to be submitted. It further clarifies that the clock begins to run again when the supplemental submission is received, but that if the application remains incomplete, the shot clock may be tolled again if the governing authority notifies the applicant within 10 days what information identified in the original notice remains missing. The order does not specify what kinds of documents state or local governments may require as part of a complete application. In addition to addressing incomplete applications, the order clarifies that the presumptively reasonable timeframes run regardless of any applicable moratoria, and that the timeframes apply to DAS or small cell facilities that are or will be used for the provision of personal wireless services. The order also affirms the Commission's earlier decision not to adopt a deemed grant remedy for state or local failures to act within the presumptively reasonable time limits, and it declines to find preferences for siting on government property are per se unlawful under Section 332C7. The third area the order addresses involves the Commission's own process under the National Environmental Policy Act, or NEPA, for reviewing the environmental effects of proposed deployments. Specifically, the order clarifies that the existing exclusion from NEPA review for antennas co-located on buildings and towers covers equipment associated with the antennas and also covers co-locations in a building's interior. The order also expands this exclusion to cover co-locations on existing structures other than buildings and towers, and it adopts a new NEPA exclusion for deployments, including deployments of new poles, where the deployment does not, deployments of new poles in utility or communications rights of way in active use for such purposes, where the deployment does not constitute a substantial increase in size over the existing utility or communications uses. These NEPA exclusions do not exempt deployments from review for effects on historic properties. However, as its fourth issue, the order does adopt measures to tailor the Commission's review of the effects of small deployments on historic properties under Section 106 of the National Historic Preservation Act. Under the Commission's existing Section 106 process, as governed by two programmatic agreements with the Advisory Council on Historic Preservation, or ACHP, many co-locations are already excluded from review, including certain co-locations on buildings. Under these agreements, however, co-locations on structures over 45 years of age are not excluded from review, even if the structures do not qualify for protection as historic and are not located in or near a historic district. The order adopts two new exclusions that apply to certain co-locations that would otherwise be subject to review solely because of the age of the underlying structure. The first applies to co-locations on utility poles and electric transmission towers where the deployment does not exceed a specified size and involves no new ground disturbance. The second applies to co-locations on buildings and other non-tower structures if there is an existing antenna on the building or structure and the new antenna meets certain requirements related to visibility and proximity to the existing antenna, complies with all zoning conditions and historic preservation conditions on existing antennas that directly mitigate or prevent effects such as camouflage or concealment requirements, and involves no new ground disturbance. In addition to adopting these two exclusions, the order also clarifies that the existing exclusions for certain co-locations on buildings extend to co-locations inside buildings. The Commission further commits in the order to working with the ACHP to adopt what the ACHP rules refer to as a program alternative in order to further tailor our Section 106 review of small facilities. The development of this program alternative will involve consultation with all stakeholders, including tribal nations, SHPOs, and state and local governments, and we expect it to conclude within 18 to 24 months. Finally, the order adopts an exemption for certain temporary towers from the Commission's requirement that parties seeking to build towers that require registration in the Antenna Structure Registration or ASR system provide local and national environmental notification. This exemption codifies a waiver the Commission established in 2013 and specifically applies to towers that will be in place for 60 days or less, require notice of construction to the Federal Aviation Administration or FAA, do not require marking or lighting under FAA regulations, will be less than 200 feet in height above ground level, will involve minimal or no ground excavation, and do not require an environmental assessment under the Commission's rules. Although the order was released on October 21st, the rules are not yet effective. The order has not yet been published in the Federal Register, and we anticipate it will be an additional 2 weeks before publication. The Section 649A rule will become effective 90 days after publication in the Federal Register, and the other rules will become effective 30 days, except that some of the new rules that create new or modified collections of information under the Paperwork Reduction Act will not be effective until after approval by the Office of Management and Budget, which generally takes about 5 months. For these rules, the Commission will publish a public notice announcing the approval by OMB and the effective date of the rules. Thank you.
Thanks, Peter. I think we had some questions about Federal Register publication. It seems like you addressed it. We have a question from Eugene, Oregon. Differing increased weight of facilities was not one of the substantial change examples listed. One of the companies has told Eugene, Oregon in meetings that co-location replacements are often of greater weight or differing weight than originally approved. Can that not trigger a new permit because it is a substantial change?
Well, as you mentioned, weight is not one of the criteria under the substantial change test. The order does provide that state and local governments can continue to apply their structural codes, building codes, and other rules reasonably related to health and safety. And I think in that context, weight may be a consideration.
Just not under the substantial change part of 6409A, but the local ordinances.
That's correct.
That. Okay. We encourage you to send more questions like the one we had from the city of Eugene, Oregon. Peter will be with us for a little while, and we built in time, a considerable amount of time for questions on 6409A because your local planning and zoning boards have to actually implement this and deal with the shot clocks. Oh, I think we have another question coming in. Oh, can you quickly hit the six? This one is. Can we quickly go over the 6 items in 6409A again? And I should mention that the presentations today will go up on our events page, but I think Peter could quickly hit the criteria again.
Sure. Okay, so to review the 6 criteria for substantial change.
Yes.
1, for towers outside of public rights-of-way, it increases the height by more than 10% or 20 feet. Or for towers in the rights-of-way and for all base stations, it increases the height by more than 10% or 10 feet. 2, for towers outside of public rights-of-way, it protrudes from the edge of the tower more than 20 feet or the width of the tower structure at the level of the appurtenance. Or for towers in the rights-of-way and for all base stations, it protrudes from the edge of the structure more than 6 feet. 3, it involves installation of more than the standard number of new equipment cabinets for the technology involved, not to exceed 4 cabinets. 4, it entails any excavation or deployment outside the current site of the tower or base station. 5, it would defeat the existing concealment elements of the tower or base station. Or 6, it does not comply with conditions associated with the prior approval of the tower or base station unless the noncompliance is due to an increase in height, width, or addition of cabinets or a new excavation that does not exceed the corresponding substantial change threshold.
Great. And Peter's presentation, I think, with all those listed, will be up on the website. We have another question from Albemarle, maybe Maryland, I'm not sure. Some of the information was stripped out of the email. If an increase in height will violate a setback, which is a condition of approval, is that a substantial change?
I think that the order doesn't specifically address that question, so I'm not sure I can go beyond what the order clearly provides, but you'd have to comply with the the height restrictions, and I think beyond that, criteria 6 would indicate that restrictions on height cannot go beyond what the applicable threshold states.
So the conditions for substantial change in the order take precedent over the local zoning if it's within whatever the order defines a substantial change as?
Yes, I think that's a fair reading.
I think so. I know that directly impacts our friends in cities and jurisdictions, and that's, Congress wrote the statute and we're implementing it. And as long as the substantial change is within is within the parameters of the order, it's not considered a substantial change as long as it doesn't go beyond that, even though it might be a substantial change for your local zoning code, if I'm saying that correctly.
Yes, that's right.
Great. Let me see. We have a few more questions coming in. Okay. We have a question from one of our attorneys in town, Jerry Lederer, who represents a lot of municipalities in his practice, in his state and local government practice, and he's asking if you can clarify if there are any different rules for cabinets in the rights of way versus traditional towers. Are there any different rules for cabinets in the rights of way versus traditional towers?
I think the order does define what is considered a site differently in that context, which can affect where you are able to put cabinets. But I'll have to actually check the order and get back to you to make sure that I have the specifics right. Okay.
This is good. Any other questions? Now's your chance. You have one of the main drafters of the item, so I think it's a good opportunity for you folks. Don't be shy. If you're thinking of the question, there are probably a lot of other people out there too wondering the same thing. We have a question from the Executive Director and General Counsel for the International Municipal Lawyers Association. To what provisions does the proprietary capacity exemption apply? For instance, in Maryland, ownership of the rights of way is considered proprietary. Would the FCC order be consistent with that law? Do you need me to read that again?
Well, the order does not attempt to examine how the principle applies in any particular context or to particular acts or provisions. It establishes the general principle that 6409A and the rules promulgated under it do not apply to state or local governments in their acting in their proprietary capacities, and generally looks to existing precedent applying that principle under other provisions like 332C7 as potential guidance.
Okay, great. I think this is very helpful. Let's see. We have a few more minutes, so if you guys out there have any more questions, please send them in. If not, we're also happy you could email myself, gregory.vatis@fcc.gov, or email peter.trachtenberg@fcc.gov if you think of the questions later. But we encourage you to ask now. Okay. We have one from the director from Carlin Reed, Director of Competition at the Massachusetts Department of Telecommunications and Cable. Well, I don't know that we'll be able to answer this. Do we have an idea of how many cell sites will be impacted by this order?
No, we
do.
We don't exactly have an.
Okay. Sorry. Okay. I guess it's safe to say potentially all. I mean, but probably not. Would you say?
Well, if you're asking how many 6409 applications are going to be filed,
yeah, or can be impacted. I mean, we don't know what the.
We don't. I mean, we have some very rough guesses as to that, but obviously our information's pretty limited at this point.
Okay. Oh, yeah, I also have a little technical bulletin popped up. If you're watching via WebEx and you're having trouble, you may want to just try to use the phone bridge and use the live feed with the volume on your computer turned down. Apparently WebEx is having some glitches. So you could call in on the phone bridge and then watch the live feed. Okay. Oh. We have one from Clarence West, an attorney, and he asks, can we discuss that a request to use public proprietary property is not an application for purposes of 6409 and the shot clock? Go ahead.
Well, I really just have to repeat my answer before. The order doesn't go into any applications of that principle, but to the extent that a state or local government is acting in a proprietary capacity, then the rule and the provision is not applicable to it.
To the extent that they're the owner of the piece of property, right?
Well, that's that is a sort of that is generally the case, would be my understanding. Yes.
As opposed to acting in their regulatory capacity.
Yes.
Okay. Oh. Okay, we have a question related to DAS from Donna Fairweather. Can you explain DAS system and city's right to not have DAS system if there is no current DAS system in place? I guess how does the order apply to DAS? Maybe to DAS.
The rule does apply to DAS. I think perhaps the question goes to the definition of base station. DAS systems are very often deploying antennas on buildings and utility poles, and under our interpretations, buildings and utility poles are not subject to 6409A unless there is already a wireless deployment that is on the structure. So, for example, if somebody were deploying a DAS antenna on a utility pole that had not already had a wireless deployment on it, it would not be treated as a base station, and therefore it would not be subject to 6409A.
Okay, we hope that answers your question. We have a question, another one about moratoria. Are moratoria per se prohibited under the rule or simply for co-location items?
Under the 6409A rule, moratoria do not toll the running of the clock for any application under 649A. So that would include co-locations, but it would also include replacements and removals.
Okay. Great. I think we've had a lot of questions. We'll just wait a minute or two to see if we have any more. I think that demonstrates the importance of this item to all of you out there and to the folks who have to implement it. Okay, we'll just give it a moment or two. Thanks, Peter. I know this is very helpful just by the number of questions we're getting today. Okay. All right, we're just going to give it a few more moments, and if we don't have any questions coming in, we're going to move on to our next topic, which will be E-rate modernization. And we're lucky to have Patrick Haley, the Associate Bureau Chief with the Wireline Competition Bureau, who can speak on this. And thank you very much, Peter. As I get more questions, I'll be sure to send them over to you, and we'll be able to get back to folks. Thank you again for your time and expertise. Thanks, Peter.
Good to go?
Yep.
Okay, I will try to boil down a very weedy subject in about 30 minutes if I can, and be happy to answer any questions. So since last summer, the FCC has been in a process to update its E-rate program, also known as the Schools and Libraries program, which has been an FCC program since the late 90s. Originally, the concept of E-rate came out of the 1996 Telecommunications Act, and the FCC took steps in the late 90s to implement the E-rate program. So I'll talk just a little bit about structurally how the program worked, focus mostly on some changes that we made to the program starting in July of this year with an order, and then talk a little bit about the process going forward to complete the process of modernizing E-rate and making it a completely broadband-focused program. So the FCC established E-rate in 1997, and the first funding year for the program was in 1998. So it's been around for about 16 years in terms of dollars actually flowing to schools and libraries. And the program since 1998 has supported telephone services and broadband connectivity and internet access for schools and libraries. The program, for those of you who are less familiar with it, just in terms of how it actually works, a school now based on the district average, used to be based on each individual school, but a school is given a discount on eligible services, which are both internet connectivity, telephone service, and a few other services. They're giving a discount on the cost of those services based on the relative level of poverty in the area. And that's determined by the percentage of students who are participating in the free and reduced school lunch program. So as you can see, if you have a very high percentage of students in the free and reduced lunch program, you can get up to 90% discount on your eligible services. And it goes down 80, 60, 50, all the way down to 20 for those who have very few people participating in the free and reduced school lunch program. So it's a discount that's based on the relative level of poverty. That's the first thing that's important. And then for certain schools that are in rural areas, there's an additional 10% bump, which you can see on the second column there. So that's the first piece. The second piece is what we fund. And historically, there's essentially been, it's a prioritization system. It still is. We now call it Category 1 and Category 2 rather than Priority 1 and Priority 2. But the prioritization is essentially telecommunications services and monthly internet access, your broadband connectivity charges, essentially connectivity to the building in form of telecommunications and internet access. Those things get first priority. So what happens is we fund all the requests that come in for those services first, from the 90% schools all the way down to the 20% schools. Then if we have any funding left over, we will then fund what are called Category 2 requests, which are for internal connections like Wi-Fi inside of a school. And it's a capped program. So right now the cap is $2.4 billion. When it was first established in 1997, the cap was $2.25 billion, and it actually stayed flat all the way up until 2010. And so in 1997, it was $2.25 billion. In 2009, it was $2.25 billion. There was no adjustment over time to account for inflation. So starting in 2010, the Commission decided to allow the cap to grow at the rate of inflation. So that's why now, in the most previous funding year for 2014, the cap is now $2.4 billion. So that's kind of how the program worked. We fund all the requests for broadband and internet and telecom services first, and then if there's any funding left over, we then would fund internal connections or Wi-Fi connectivity, starting again at the 90% schools and going down. For the last two funding years, we have not had any funding available for Category 2 internal connections. There's been no funding available in funding year 13 or funding year 14 for Wi-Fi, simply because the cap was already reached to fund the Category 1 services. So we saw that as a major problem and something that needed to be addressed. In 1998, a Wi-Fi router in a classroom was kind of a nice to have. In 2014, every school in the country is moving towards a model that envisions, robust internet connectivity, not just to the building, but right down to the student's desk. And so we actually saw a fairly significant problem in that there was never funding available. There was no funding available for Wi-Fi. And even in the previous 3 to 4 funding years where we did have some funding available for Wi-Fi, it was only going to a very small percentage, less than 10% of schools and less than 5% of libraries were getting any funding at all for Wi-Fi. And so we at the same time, looking at organizations who were doing surveys about school Wi-Fi capability, we found that about 2/3 of schools did not have sufficient Wi-Fi. About 40% had no Wi-Fi at all. And so in July, when we adopted it in order to modernize the E-rate program, a large focus of that item was on meeting this Wi-Fi gap. So to talk a little bit about that order. So we went through a rulemaking process over the summer and into the first part of this year. And in July, the Commission adopted an item, and it did a couple important things. One, it significantly expanded Wi-Fi funding for schools and libraries. We set an annual target of $1 billion annually to make available for Wi-Fi. It was a clear recognition by the Commission that broadband connectivity to the building is important, but it doesn't stop there, and we need to extend broadband all the way to the desk through wireless connectivity in every classroom and in every library space. So we changed the methodology for how we distribute funds for Wi-Fi connectivity to try to make it more equitable in the sense that we will have a specific target of $1 billion annually, but also we would change the methodology to make sure that every school was able to get money for Wi-Fi, not just a small percentage like the old rules, which was going on with the old rules. We also took steps to improve cost effectiveness. One of the problems we were seeing as we were going through the rulemaking process is a very wide variation in costs, or prices, I should say, being paid for the very same services by schools within the same state, certainly across state lines. A gigabit connection in one state on a state master contract might cost $750 a month. That same connection might be $5,000 in a neighboring state. And so the question was, well, what could we do to try to lower prices for schools? It's called the E-rate program. What could we do to give schools the best rate and libraries the best rate? Even schools within the same county, neighboring counties rather, within the same state, from the same provider, would have very different prices that the E-rate program was funding. And so one of our objectives was to try to increase the transparency about what was being purchased and for how much. So there's a new transparency requirement so that every district, every state and local government will know what the schools are purchasing, at what price, and from what provider, to get a sense of what's out there and what prices are potentially available. And it's not a knock on any schools who might be purchasing at higher speeds or carriers who are charging higher prices, rather. It's just the nature of a competitive bidding system. You put out a bid for what you want, you get the responses, and then you select. But our goal is to try to make as much information as possible available so that people can be smart about their negotiating and make sure that they get the best price for the service that they need. So there's a major emphasis on transparency and other steps, whatever we can do to try to make the price as low as possible for schools and libraries. And then we did some steps to streamline the application process. The whole thing is going online. We're trying to improve the IT of USAC, the Universal Service Administrative Company, which is the entity that administers the program for us. That's where all the actual applications get submitted. USAC.org is a good website if you're interested in learning more about the details of E-rate. So we've done a lot to try to streamline that process, get applications reviewed faster, get funding flowing earlier in the year than we have in past years. And perhaps most importantly in many ways is that we adopted important program goals and speed targets for the program. So our objective was to move the program from one that was largely focused on voice to a program that was entirely focused on broadband. So in saying that, one of the things that we've done in July, the Commission voted to phase out support for voice service. So over the next 5 years, the Commission will be phasing down support for voice service so that the program will only support broadband connectivity. Now, we did that knowing that schools do, of course, have needs for voice. They need to have a phone, they need to have telephone service. But for a program that was capped, and we were consistently getting requests for more service than we could fund under a capped program, the determination by the Commission was made that it's the biggest bang for our buck in terms of education and improving outcomes for students and teachers was to focus our funding on broadband, not on telephone service. And so over the next 5 years, support for voice will phase down by 20% each year over the next 5 years. So if you're a school today that gets a 90% discount, this next funding year it'll be 70, down to 50, down to 30, et cetera. So that process is underway. But as we then make this program a broadband program, the question is, well, how are we measuring success? And so we established some very important benchmarks and important speed targets. And the goal of the program is, I'm paraphrasing here, but it's essentially very high-speed broadband connectivity to every school and robust internet access within every library. And the speed targets we've established are based on recommendations from the State Educational Technology Directors Association for Schools, which is 100 megabits per second per 1,000 students in the short term, scalable to a gigabit per second per 1,000 students in the long term. And so a gigabit connection is pretty robust. But the reality today is there are far too many schools that don't have 100 megabits. There are a lot of schools that have 10 megabits. That's less than I have at my house for 4 people, let alone a school of 100 people or 200 or 300 people. So our objective is essentially, and largely those are schools that are using some form of a T1, a dedicated line at a very low speed. Our objective is to get every school up to a very high-speed connection, assuming that they want that connection, which most do. And if we're going to do that, we needed to have speed targets, so we adopted these speed targets. We also have speed targets for libraries as well, depending on the size of the community. And so the way we look at the next step in the modernization process is how many schools are out there that don't have that capability today because they can't afford it or because it's literally not available to them? And what is it that we as the FCC can do to make it possible for every school in the country to have a high-speed connection? So today we estimate that 41% of rural school districts don't have a fiber connection, don't have access to fiber. It's not there. And 31% of urban schools don't have fiber. That's not to suggest that every school necessarily needs fiber, but I think the general perception is that to meet the level of speed targets that we've adopted, fiber is the most cost-effective technology for most of these schools. And the fact that 41% of rural schools don't have access and 31% of urban is a problem, and that's something that we want to fix. So I talked about the goals already. Here they are. You can see them, and I think the slides are going to be made available, right?
Yes.
Okay, so this is a little bit more about what the specific targets are for school and library broadband connectivity. I talked about Wi-Fi already. One thing that we're doing differently with Wi-Fi that you all should be aware of is we're essentially providing a known amount in advance for every school district in the country. So for the next 5 years, every school, if a school wants to opt in for funding for Wi-Fi connectivity within the E-rate program right now, they essentially will have a budget of a 5-year period that says based on the size of the school, here's the amount of funding that will be made available to the school over the next 5 years. It's at the discretion of the district to determine how much money of that 5-year total budget that they would want to use in any given funding year. So you could use 20% of it each year. You could use a little bit more up front and less on the back end, or vice versa, depending on where an individual school is in its Wi-Fi deployment cycle, if you will. And that's a change from how we did this in the past, and that's new. We're trying to educate all the schools that we possibly can about how that works. But at least for the next 2 funding years, as of right now, that new methodology of a budget-based approach to Wi-Fi funding is what's going to be done. I talked already about maximizing cost effectiveness with greater transparency in the program. And I talked a little bit more about trying to make the program as efficient and streamlined for applicants as possible. And we're doing a lot of that already. We're continuing to do it on a daily basis. I would note for those of you out there who have a significant number of schools on tribal lands, we are very conscious of the fact that broadband connectivity levels on tribal lands are discouragingly low compared to other areas, and we are specifically setting up a tribal liaison at USAC, the third-party administrator of the program. We're working closely with our Wireline Bureau and our Office of Native Affairs and Policy, ONAP, to set up a tribal consultation, training, and outreach program. We actually just had a training in New Mexico on November 19th, specifically trying to reach out to tribal schools and libraries. So we're going to try to do a lot more on that front going forward as well. So since the order in July, we've done a lot. We have put out two staff papers with a significant amount of data in the record, looking at current level of school and library broadband connectivity, and then doing some analysis on the potential costs associated with upgrading all schools to a connection capable of meeting the speed targets that we adopted in July. Looking at the long-term funding needs of the program. One thing we didn't do in July was adjust the cap, so that's why the cap is still $2.4 billion for the program. But we sought comment and a further notice of proposed rulemaking in July to say, what are the long-term funding needs of the program, right? Recognizing that we haven't really adjusted the cap since it started. If we're going to actually get all of the schools in this country up to a broadband connection capable of meeting the speed targets we've just adopted here, a gigabit per 1,000 students, what level of funding will it take to get all those schools that today can't meet that target? So we've done a lot since July, between July and now, looking at where we stand today, our best estimate of where school connectivity and library connectivity is today, and the cost associated with upgrading all those schools and libraries to meet those targets. So we put out a lot of analysis on that. We've released a school and library fiber map. There's a website on this page. I encourage you to take a look at it. And it's based on the best data we have from E-rate applicants directly, from conversations with states and individual districts, from discussions with carriers and our federal partners who have provided funding for school connectivity. And based on all of the data we have, we've put a map up there which you can go to, which shows down to the district level and down to individual library our best estimate of where fiber is available for those schools. And so where we are at in the process right now is it's an important point in the process. We took a big step forward in July. We put a greater emphasis on Wi-Fi connectivity. I'll come back to that. We established long-term goals for the program with specific speed targets. We tried to make the program more transparent and make sure that every purchase that we support through this program is as cost-effective as possible. We set a $1 billion annual funding target for Wi-Fi. And we tried to streamline the application for the program. So it was a big step forward. And at the same time, there are two things we really didn't do. One is we didn't address long-term funding needs of the program. We sought further comment on what those funding needs are. And two, we didn't really make any major changes to the rules in terms of building infrastructure out, getting infrastructure built out in areas that don't have a connection capable of meeting the speed targets we just adopted in July. We just didn't have the record to move forward on those points. So where we are in the process now is trying to tackle those two issues, which is to say, what is necessary, what does the FCC have to do to get broadband to every one of those schools? We already took steps on Wi-Fi. We changed the methodology for how we are going to fund Wi-Fi, and we've addressed the need for funding it. But what about all those schools? What about the 41% of schools who don't have fiber today in rural areas? What about the 31% who don't have it in urban areas? There's some statistics that we've seen in the last couple months from various reports from school, national level education groups. 6% of schools received no response to their E-rate RFP. Well, that's not acceptable. So they have a broadband connectivity need. They just aren't able to get anyone to bid on their service. What can we do to help that school? 26% only got one response to their E-rate RFP. So if you add those together, that's a third of all E-rate applicants who have no choice in terms of the provider. And that can have a negative impact. It can be a very costly endeavor for that school, right? So, and same survey, 38% of schools said that the high cost of building out, of upgrading their infrastructure, the one-time sort of capital costs associated with upgrading their infrastructure, 38% said that was a major impediment to them meeting their broadband connectivity goals. It was the second highest response after high price. So this next order that we're teed up for December 11th at the commission, the chairman has already announced his proposal, which is to increase the E-rate cap by $1.5 billion. So the cap would grow from $2.4 billion being available annually for E-rate to $3.9 billion being available for E-rate. That's not an insignificant step, obviously, and that's based on a significant amount of data analysis based on our best estimate over the long term of what will be needed to meet the needs of schools and libraries. And it's that level of funding is based on a couple of factors. One, if we're going to be able to meet our annual $1 billion target for school and library Wi-Fi connectivity, that's a big piece of it. Two, for the 41% of rural schools and the 31% of urban schools that don't have a fiber connection and aren't able to meet our speed targets today, upgrading those networks, that's going to be a cost, right? It's not inexpensive to upgrade those schools to a high-capacity broadband connection. And once you get every school with Wi-Fi in all their classrooms, their demand for internet access, their monthly bandwidth demands are going to go up. So too are the monthly demand is going to go up for those schools who get access to a fiber connection that doesn't have that today. And so you have one-time costs associated with upgrading schools that don't have that connection today, and you have monthly costs that are going to go up over time. And hopefully we will see reductions in price over time at the same time. But no analysis has shown that we'll be able to meet the demand for broadband growth and have price reductions at nearly the same levels. And thus, that's why we think we need to put a little more funding into this program. And I guess the last thing I would say is this order in December that we're considering, it's not just about more money. It's also about modifications to our rules that make it easier and more attractive and create more opportunities for schools to take advantage of that funding to upgrade those connections where they don't have access to a high-speed connection today. When I say that, I mean a connection capable of actually meeting the program goals we adopted in July. And so we're proposing a series of changes to those rules to make it easier for those schools that can't get anyone to bid on their response or can't afford the current charges, and therefore they can't justify upgrading their network because it's just too expensive. So there's a series of policy steps that we're looking at to make it possible for those who literally can't get anyone to provide them the service that they need, or to try to create some more competitive options to make it possible for every school to meet the targets that we just adopted. So that's on the agenda for December 11th, and it should be an interesting meeting. And with that, I'm happy to take any questions.
Thanks, Patrick. Let me ask you about the 100 megabits per 1,000 students in the short term and the 1 gigabit per 1,000 in the long term. Could you define short and long term? Maybe some folks out there are wondering.
Well, it's based on recommendations of the State Education Technology Directors Association, or CETA. And their recommendations, short term is 2014-15, with scaling up to a gigabit in 2017 to 2019. But I mean, our objective is to get everybody onto a gigabit per 100 students as soon as we can. It's just not an immediate target.
But fairly close. Long
Yeah.
term.
Long term
is
yeah.
not 10 years
That's right.
out.
And we'll continue to look at it, right? Somebody may need 100 megabits today, scalable to a gigabit, and that may be too low 10 years from now. To be clear, it's not a requirement, right? We're not requiring a school to have a gigabit connection. For many rural schools, you may not need that level of connection even to meet our target. It's a gigabit per 1,000 students. So if 100 megabits per second connection is sufficient, that's fine. And as it has always been, the application determines what it is that they need, and so we're not requiring anybody to purchase fiber or requiring anybody to have a gigabit in the near term. That's just a target for the program that we're aiming to achieve.
Great, thanks. Also, could you speak a little bit about? I think I know you had a slide on it. I don't know. I'm not sure that you got to about the harmonization of the Connect America Fund.
Sure.
To E-rate, how
Sure.
we're trying to harmonize our universal service programs.
Sure. So the E-rate program, as I say today, is $2.4 billion. The E-rate is just part of a broader universal service fund, right? So the biggest program within the universal service fund umbrella is our high cost program, also known as the Connect America Fund, and that is a fund that provides support to carriers, directly to carriers to serve rural areas. And it's $4.5 billion annually that we collect for funding carriers to serve rural areas. It's essentially more of a residential program than it is a community anchor program. Nonetheless, we, in 2011, when we reformed our Connect America Fund, our high cost program, we made clear that recipients of our high cost dollars, that there's an expectation that they serve community anchor institutions at the speeds and service levels that those anchor institutions need, and at rates that are reasonably comparable to rates charged to similar entities in urban areas. But we never have codified that in the sense of what the specific obligation is. And so one of the things that's under consideration right now is what does that mean? And so there is an overall desire to try to harmonize our programs, and so we're looking at, in this context of E-rate modernization, looking at, well, what is the requirement for those carriers who get the $4.5 billion of high cost subsidy to build out in rural areas? What is their requirement in terms of serving rural high cost schools and libraries? And that's something that's very much on the table right now.
Great, thank you very much. And it's fair to say this is one of the chairman's big priorities, E-rate and all of universal service, and it's good to see that we're working across all our universal service programs towards the same goal of high-speed broadband for all.
Yep, great.
Thank you so much for your time, and Patrick's presentation will be up on the on our events page on the website. I encourage all of you to go to it. It has a lot of useful information, links to past orders, references the Connect America Fund docket if you want to take a look at that. It's a great presentation and good source of information for all of you out there. And please tune into the December 11th Commission meeting to hear more about the E-rate order that will be adopted. Thank you very much, Patrick. Great. Next up, we have Matthew Del Nero, Deputy Bureau Chief in the Wireline Competition Bureau. Matthew's here to speak about technology transitions that are taking place, have been taking place, and will be taking place in all your states and municipalities. And we know a lot of your offices are probably hearing from your constituents, consumers, as copper offerings, traditional telephone or POTS starts to be replaced by an all IP network, and Matt's going to discuss the issues surrounding this. So thanks.
Great. Thanks very much for having me here, Greg. What I thought I'd discuss today, I know we've on a few occasions at these webinars talked about technology transitions. Wanted to focus today on some very recent action by the Commission, which is the adoption of a notice of proposed rulemaking and a declaratory ruling around technology transitions. This was just adopted on November 21st and released to the public on the 25th. I'll include a link to it at the end of this presentation, which will be posted on the fcc.gov site. And I think you'll find it hopefully timely and relevant. Just by way of background, as we've previously talked about, in January of this year, the Commission adopted a technology transitions order that was authorizing experiments and other data gathering initiatives to really better understand how are these historic technology transitions affecting consumers, affecting businesses that rely on the network. The record since then, in part in response to that, has reflected, in addition to very helpful input on those factual questions, has reflected some important policy questions, both around consumer protection, around public safety, around competition. So what this NPRM does is really provide a vehicle for addressing many of those questions. That's not to say it will be to the exclusion of continuing the fact-gathering efforts that were kicked off in January. The experiments will proceed in parallel with those. As you know, AT&T is planning a trial in 2 wire centers. CenturyLink recently announced a trial on which we're seeking comment. So those will continue and will continue to help inform these questions. But at the same time, we saw some pressing policy questions that we thought it worth beginning to seek comment on and take action on. I should also say, one thing that should not be lost in all of this is that these transitions that are happening are tremendously beneficial, and we encourage them. I think Commissioner O'Reilly, in his statement to the NPRM, made a very good point that these are positive advancements that ought to be encouraged. And so we're very excited about the transitions. It's really an issue of not whether transition, but really how, and how we can make sure that in that transition, what we call the network compact is fulfilled. These are really the first principles on which we're guided: competition, universal access, consumer protection, and public safety and national security. And I previously have done a presentation like this and had them listed really in separate boxes, and the more it occurred to me is they really overlap quite frequently, as we'll see today in discussing the NPRM and declaratory ruling. So at the end of the day, we all know we'll be measured by our ability to bring forward these values with the technology, and we think that best serves the public. The goals of this particular item that was just adopted by the Commission at a high level, really to facilitate technology transitions to next-gen networks via common-sense, technology-neutral rules. And we zeroed in on 3 areas, again, based in part on a lot of the things we were hearing in response to the January order. One is ensuring reliable backup power for residential voice service at the home, making sure, essentially, that people can call 911, can reach loved ones when the power goes out to their residents. 2 is protecting consumers by ensuring that they're informed about their choices when networks are being changed or services are being discontinued. And 3 is preserving competition where it exists today so that competitive choices remain available to the public. I'll start with that first one on continuity of power. And it's an issue that has come up, I think, most directly when we see incumbent LECs moving from copper to fiber networks, but it's not just a copper to fiber question. The basic background, fiber-based networks obviously bring tremendous benefits to consumers in terms of access to very high-speed broadband and other innovative services. But these new networks, whether it's fiber, coax, unlike copper networks, they just have a different profile when the power goes out to the consumer's residence. Namely, a copper network, simple matter of physics, could conduct line power back to the consumer's home and therefore power the consumer's equipment so they could still make phone calls even when the power was out. That's just something, as a matter of physics, that a fiber network is not going to do. And with a fiber network or a coax network or, say, a fixed wireless network, what you need instead is an access to some kind of alternative power source when the commercial power is out. Basically, that today means battery backup. And what we were seeing is a lot of variation in the amount of battery backup that consumers are given access to, depending just upon maybe where they live, what service they used to have, what provider they're with. Some might have as much as 24 hours of backup. Others might have 8. Some might have none. And so there wasn't really a sort of baseline expectation of what consumers can expect in terms of continued access to their communication services when the power goes out to their residents. And so what the NPRM would propose to do is establish essentially a baseline, so what all consumers can expect in this area. And we're focused here on facilities-based residential voice service. The idea is if a consumer has really replaced their sort of copper-based landline with what would seem to them to be another landline option, they generally will have certain expectations about how that will work in a power outage. And so this wouldn't affect, for example, this wouldn't impose rules on battery backup for commercial mobile networks. That's not part of this proceeding. But certainly for, say, an interconnected VoIP like that a lot of the cable companies offer, or an interconnected VoIP that is offered typically over fiber, or even some of the legacy services that are offered over fiber. It would set a baseline for battery backup on these networks. The framework that is set forth would, for example, require that the incumbent, that the provider ensure a solution with battery backup power capable of working for the first 8 hours after an outage. We note in the NPRM that some parties, for example, Verizon has a D-cell battery solution that's offering 24 hours, so there certainly are solutions offering more than that, and we see comment generally on what the right number is. But at least as a matter of the sort of starting off the gate proposal is 8 hours. And then there's questions for what happens after that. What happens after that 8 hours? How does the consumer self-provision battery backup power? How do they at least have that opportunity? Is there a consumer education plan so consumers are aware of how much battery backup power they have and what to do after that? And then there are broader questions about what happens in an extended outage, let's say an outage lasting more than 72 hours. So a lot of questions in this area, but as I say again, the overall goal of establishing some baseline here for what consumers can expect. Recognizing that, often it's in times of emergency that the power goes out, say a major storm, and that's often when consumers might have the greatest need to call 911 or to reach a loved one outside of their home. The next piece of this, and this is really be parts 2 and 3, concerns consumers and competition. So as I say, protecting consumers, preserving competition. And it's worth taking a moment to provide an overview of the sort of legal framework. What are the levers that we have to use in achieving these goals and technology transitions? And it really depends on whether you're talking about a change in facilities or a change in services. And let me talk a little bit about that. With facilities, what we're talking about is the physical infrastructure of the network changing. So the most obvious one being when a copper network is shut off, taken out of service, replaced with fiber, with fixed wireless, with something else. A service might be offered over any number of different infrastructure, but when a service is discontinued, so let's say if a carrier wanted to get rid of basic voice service, POTS, that triggers Section 214A of the Communications Act, which puts a responsibility on the Commission to oversee that and to not allow the service discontinuance until a decision has been made that doing so would comply with our rules and essentially be in the public interest on balance. When you're just talking about a facility change, if you're just talking about the copper being replaced with fiber and all the same services will still be offered over that, that's a different set of rules. It's really more of a notification process rather than a need to actually obtain permission. And that's really as a matter of our statute. Just thought it might help to give a little bit of that background as we set the stage. But let's go to part 2, protecting consumers. And I show here from our friends at National Park Service a photo of Watch Hill in Fire Island, because the Fire Island situation, which I'm sure you know well, gave us important insight, as tragic as it was. The fact that there was a proposal to replace wireline with fixed wireless service, and there was a debate over whether that proposed new service would meet the needs of the community, really provided some important insight for all stakeholders, for the providers, for the commission, for the state and local regulators, for consumers, businesses, everyone really. And so we want to learn from what we learned from Fire Island. And I think one thing it also did was highlighted for us the importance of not doing this on an ad hoc basis when we get, say, instead of one isolated incident where a carrier is looking to discontinue a legacy services and make a mass transition, but where a carrier understandably comes to us and really wants to do sort of en masse a wide-scale technology transition. We wouldn't want to handle that on an ad hoc basis. We really want to have our ducks in a row and be ready for how we're going to evaluate those kind of applications and make sure we have the right procedures and processes in place. So, for example, copper retirement comes up. The January order, the technology transitions order that I mentioned earlier, recognized that carriers rationally will seek to retire copper at some what we call the tipping point. So, for example, if a carrier has built out an all-fiber network in that same area, they're probably not going to want to keep the copper operating forever. That's an expense. So we recognize that. But one of the concerns is that the current copper retirement rules really don't have any provision for consumers. They're focused on the needs of interconnecting carriers when copper is retired, but they don't really give any reference to how do you inform consumers, how do you make sure that they have the information they need so that they're not caught off guard. And so there's some basic proposals in the NPRM around that. Let's have some basic notice to consumers, education for consumers before the copper is retired. We also note the presence in the record, including some filings that were made by Public Knowledge, TURN, and some other public interest organizations, containing allegations of that in some cases carriers were retiring copper networks in a way that was not transparent to consumers, that raised other consumer protection concerns, for example, allegations of upselling in the process. The NPRM doesn't make a finding on whether those are whether those allegations are founded or not, but it does seek comment on them and notes the concern in seeing them. Also asks, based on those allegations, do they tell us anything about what we should do in particular in this area? We also, and this will be important for this group, seek comment on the roles of states, localities, and tribal networks, tribal nations, recognizing, of course, that all three types of entities have played a vital role in overseeing carriers' service quality and network maintenance. Exactly the sorts of issues that we've seen some of these allegations around of lack of maintenance of networks. We're emphasizing in this that we're in no way seeking to revisit or alter the Commission's past determination that states have authority, preserve authority, with respect to requirements for copper networks. But we do note, for example, Public Knowledge and others have pointed out that in some states, legislatures have removed state-level authorities' ability to ensure customers have meaningful access to some consumer services. That's Public Knowledge's point. And so we ask, well, based on that, how prevalent is that trend, and what does that trend tell us about what we should do in this proceeding? So it certainly will be helpful to hear from states, localities, and tribal nations on that point. Also, we look at how consumers are affected when services discontinue. Again, different from turning off a network, so going from copper to fiber. Here we're talking about a service, so for example, POTS. Again, Section 214A provides the FCC with the responsibility to oversee service discontinuances. But we're aware that today, if we suddenly got, say, 1,000 discontinuation applications from a large incumbent to discontinue, basic voice service throughout their territory in place of some other service, it wouldn't entirely be clear to us how exactly to evaluate that in a systematic way, and probably wouldn't necessarily be clear to the entity as to what they would need to show. And so we seek comment on whether the FCC should establish criteria for defining adequate substitutes for services a carrier seeks to take off the market, meaning what would the carrier essentially need to show that the substitute services that would still be available to the to the public would need to do to be adequate, so that we could all feel comfortable saying, okay, you can take the legacy service off the market because we know that there's something waiting for consumers that they can switch to that will meet their basic needs that were met by the old service. We note some suggestions that were in the record around areas like call quality, like access to public safety services, services for the disabled, and a number of others, but we also make clear that we're broadly seeking comment on what sort of criteria the Commission should use. And I include this quote here because one thing that we recognize, the Commission recognizes in this, is, again, everyone concerned, both the providers and the public and the regulators at all level, would be best served by our articulation of criteria now, rather than simply trying to handle on an ad hoc basis large number of applications at such time that carriers are ready to discontinue legacy services en masse. We think that'll make it more efficient and effective, make it more likely that we both promote the transitions and that we preserve those core values that I mentioned earlier. Moving to part 3 is preserving competitive choices, and one thing we're focused on here in particular is competitive carriers and the competitive alternatives that they've offered, in particular to the non-residential market. So we see, for example, small and medium-sized businesses, hospitals, schools, libraries, and other purchasers of enterprise services rely to a large degree on competitive carriers as their main alternative to incumbents when they're purchasing enterprise services. And this pie chart is from data that was submitted by a competitive carrier, but is from an independent market research firm, GeoResults, and shows that, so essentially your non-residential customer expenditures are about 58% with ILEX. The next largest group would be the competitive carriers with 26%. And those, we're aware that those competitive carriers, in providing those alternatives, often are using services over the last mile provided by the incumbent. So the most obvious, for example, would be DS1 and 3 special access services. And one of the things we hear from those competitive carriers and from many of their customers, in fact, is that they worry about what's going to happen when those legacy TDM services that are used as wholesale inputs go away. Will there still be a competitive alternative or not if those wholesale inputs go away? And obviously, no one wants to stand in the way of a transition to a new IP-based service, but the question is, what sort of access would the competitive carrier have to that new service? And so what we propose, I'm going to jump forward to services here. There's a tentative conclusion as to the standard that the Commission would use in evaluating applications to discontinue the incumbent service that is used as a wholesale input. And the idea would be that one option is the incumbent can continue to offer the legacy wholesale input service. The other is they could replace it, but in replacing it have to commit to provide the competitive carriers with equivalent wholesale access on equivalent rates, terms, and conditions. And that's a tentative conclusion in the NPRM. And then, of course, we seek comment on important questions like, okay, assuming we adopt that tentative conclusion, what does it really mean to provide equivalent wholesale access? And how long should the duration be? So this would be a condition of receiving permission to discontinue the legacy service under 214A. Well, how long does that commitment last? And one important question is, how does the duration of the commitment relate to the conclusion of the special access proceeding? And we seek comment on that, recognizing that the special access rules, that proceeding, once completed, may answer a lot of those questions. So we, again, seek comment on that. I also should mention, and I just went a little bit out of order here, but we also note copper retirement can affect competitive carriers as well. A number of competitive carriers have noted that they are using, for example, Ethernet over copper loops to provide fairly high-speed broadband service, up to 200 megabits a second, to businesses, large and small. And so they need at least a fair bit of notice to get ready to have an alternative in place when an incumbent is retiring its copper network. So we propose tightening up the definition of copper retirement to make clear when that obligation to provide notice of retiring copper occurs, to provide some more information to the affected interconnecting carriers. And then we also consider whether there should be greater notice to states and to other stakeholders when there are these copper retirements, similar to the types of notifications that today go to states for service discontinuance applications under 214. We also note there is some presence in the record of an interest by competitive carriers to purchase retired copper networks to make use of that asset, which would be very nice if that asset can continue to be used by a party who finds it can serve their needs. AT&T, in fact, has offered that it would be interested in selling copper networks that it's retiring. So we ask whether there is some way the Commission can help facilitate the sale or auction of copper to be retired. We also ask whether there really is interest in buying copper to be retired, and recognize there may be some challenges in that. But the Commission felt it worth at least seeking comment to figure out whether this is something of interest and whether there's a way the Commission could help. That takes us last. Everything I've talked about so far has been in the realm of a notice of proposed rulemaking. So they're just that, proposals. The Commission will be taking comment on them, and then for them to turn into rules, the Commission would need to take further action. This last part, though, is in the realm of a declaratory ruling, and it concerns what might seem to be a sort of in-the-weeds issue, but one that the Commission found has an important consequence, and it has to do with how we apply Section 214A. As I mentioned, that's kind of our core directive from Congress in terms of overseeing the removal of services from the marketplace by carriers. And this started really in Fire Island. There had been some debate over whether the replacement service, whether the switch from the old service to the replacement wireless service really triggered a 214 filing, if perhaps it was going to be the same service for purposes of 214A. And what the declaratory ruling says is, well, in determining whether or not something is part of the service, which really means determining whether or not the 214A and that public process for evaluating the discontinuance is triggered, we take a functional approach to it. We don't just look at necessarily, okay, the tariff says it does these three things. Does the replacement product do those three things? If so, then there's no 214 filing. We take a functional look and say, well, is the functionality that is going to be lost in the change part of the expectation of the community? Have they come to rely on that functionality? And if I could make it sort of more concrete, one thing that came up in Fire Island, of course, was things like home alarms and medical alert services, even fax machines, which it turns out are still greatly used in the healthcare industry, doctors to pharmacies, for example. And so even if the tariff didn't say, yes, we support medical alert and home alarms, the fact that the community was using those services was relevant in determining that, yes, that's part of the service, and if what you're doing is taking that functionality out of commission, you at least need to seek approval, and that creates a public process to take comment on and ensure that there's a determination in the public interest. That does not necessarily mean that just because someone has to file a 214A that it means they can't discontinue the service, right? 214A is just a filing to seek permission, and the Commission, of course, frequently grants permission for those discontinuances, but it at least affords that public process. We also emphasize that we're not saying that every part of every functionality supported by a network is part of the service. Again, it's taking a functional look and considering the extent of community reliance on a particular functionality. That ends the discussion of the declaratory ruling. I thought it would be worth putting a concluding thought in here, which was from Chairman Wheeler's statement that accompanied the item. And the part of the quote that doesn't appear here is saying this is not an issue of old versus new technologies. It's really, the question is, as we reach the tipping point at which older networks and services are going to be turned off, will the transitions to the next-gen networks benefit all Americans, or will we allow some to fall through the cracks? And he says, I firmly believe we can facilitate the transitions even while ensuring that the benefits accrue to everyone. And that's really our goal here, is facilitate transitions, but in a way that will benefit everyone and ensure that no one slips through the cracks. That's, frankly, the Commission has been through other transitions like that. You can think about, for example, the DTV transition, where everyone knew we wanted to get from analog to digital. There were tremendous benefits to doing that to both the public and other segments of the industry, but great care was taken to make sure that consumers didn't fall through the cracks in the process. And I think that's a fair analogy for what we're trying to do here. Lastly, I wanted to say that comments are very welcome on this NPRM. We hope states, localities, tribal nations will comment, and we really do need your input and your experience, because you are the folks who are closest to how the transitions are occurring, how they're benefiting, and how they're affecting consumers. The comment deadline will be 30 days after Federal Register publication of the Notice of Proposed Rulemaking. Reply comments 60 days after that. Hasn't yet appeared in the Federal Register. As many of you may know, that can take a few weeks. But we will put out a public notice just to make sure everyone is aware when it goes in the Federal Register and what the comment deadline will be. And I've also included here a link to the NPRM and declaratory ruling, and I'd encourage you to take a look at it.
Matt, thanks. That was so informative. Thank you. Discussion along with the presentation that'll go up on the website, I think, helped answer hopefully quite a few questions. As Matt said, we would like your comments. We'd like to hear from states, localities, tribal nations. You're the folks who are hearing from your consumers, and in some instances, your purchasers of these services as well. We have a few questions. We have one tweeted into us from North Carolina Public Broadband. I think you've probably touched on it, but let me read the question. Why are you assuming that copper can't do IP? It's been transmitting IP for years. This is a myth to end POTS in rural areas, plain old telephone service. So.
Yes, thanks for the question. I'd actually agree, and we note in the NPRM that copper can do IP. And in fact, as I mentioned, competitive local exchange carriers, many of them like XO, are offering Ethernet over copper at pretty high speeds of up to 200 megabits per second. We've seen some technologies that, at least at shorter distance, allow even higher speeds. So definitely, I would say copper can provide IP-based services. What I think we're trying to do is prepare for the fact that where providers have put in fiber, they understandably are not necessarily interested in operating both a fiber and a copper network. And once there is a sort of critical mass on the fiber network, we are already seeing carriers with interest in retiring the copper, not operating two parallel networks. And so the question is, how can we facilitate that transition in a way that doesn't leave consumers behind?
Yeah. And as you mentioned, AT&T is looking to sell parts of its copper network. So.
Yes, so they had the idea and came to us, and we were very interested in saying, well, AT&T in certain areas, particularly where they do, all fiber build out, will be looking to retire the copper network, and can they sell it to, say, a competitive local exchange carrier who would run it and then operate basically a competitive service? So that would be we're very interested in knowing if that's of interest, if that's something that competitive LECs feel is feasible. Frankly, early on, we've heard differing views on that, so definitely welcome comment on it.
So North Carolina Broadband, please comment in the record. So we have your official comments in the proceeding. We also have another question from local government here in Fairfax County. Their Communications Policy and Regulatory Division. I think you also touched on that, but maybe you could elaborate a little more. Is the FCC inviting comment on the ability of battery backup systems after the power is theoretically exhausted, say at 8 hours, to nonetheless have residual power in the battery to allow the homeowners to access 911 or other emergency services? If so, what would be the amount of power in terms of time that the consumers could access? And will the FCC require cable providers to educate consumers about the availability of this additional residual power and how to utilize it? So the main question is the FCC inviting comment on the ability of battery backup systems after the power is exhausted to nonetheless have residual power in the battery to allow the homeowners to access 911 or other emergency services?
Yes, we've asked a lot of questions, and I think some of them would certainly encompass that concept. So we're interested in understanding kind of what are the minimum services that would need to be powered by the battery backup. And I would think residual power and residual power's ability to allow, for example, a call at least to 911 would be of interest. I think we're seeking broad comment on that issue. So definitely, if there's a concept out there about how you can get more life out of the battery, including a little bit of residual life and what that could do, that would be interesting. On the question about cable companies, as I say, we want this to be a technology-neutral rule for all fixed voice networks, including potentially fixed wireless networks as well as cable. So the idea would be it would not just apply to, say, ILECs who have gone from copper to fiber. And we, in the NPRM, also look at how can we ensure that there is consumers are being educated as to what the capabilities are of the battery backup that they're provided with and how the consumers can supplement that for beyond whatever the minimum required supported time is.
Great.
And I also wanted to mention, I should have said early on that we've worked very closely, and really the brainpower for the battery backup part of the NPRM is with our Public Safety and Homeland Security Bureau, with Admiral Dave Simpson and Nikki McGinnis and Brian Hurley and others in the Public Safety Bureau. And they have been following very closely developments of, for example, the CISRIC on looking at these same issues. So we and they will definitely welcome any kind of feedback we can receive about technical capabilities, other options that are out there.
Thank you so much. CISRIC is one of our the FCC's the FCC's advisory committees, communications, security, and
reliability.
Reliability. Thanks, Matt. So we're hearing, and that's made up of a number of different stakeholders. So we're hearing from industry, government, every public safety officials, and as Matt said, we're working within the agency to bring all that information together. But we still would love to hear from you. So if anybody else has a question or a comment like Fairfax, please go ahead and comment in the record.
Yes, that's a nice thing about an NPRM. We're at the stage where really, we try to set out in the NPRM kind of here's what we're currently thinking, but we ask a lot of questions because we certainly don't have a monopoly on all the ideas, and now is definitely your opportunity to help educate us as to what the right answers would be.
Okay. Thank you very much, Matt.
Okay.
We really appreciate
Great.
your time and expertise today.
Thank you, Greg.
Thank you.
All right.
Okay. Thanks, everybody. And that concludes. Oh, wait, Matt, don't run. Yeah. We have one more.
All right.
Okay.
It'll be the hard one.
We have one coming from the Marin Telecommunications Agency in San Rafael, California. In our area, in the San Francisco Bay Area, one of the companies is not building out fiber to residential end users, so a transition from copper sounds like it would be a big concern. How will residential customers be served where the incumbent doesn't build out fiber to the home? The fiber service isn't available in many local suburban areas.
So in those situations, I think what you're referring to would be the copper being retired but replaced, for example, with a wireless alternative is one option we've heard, or no alternative. In that situation, you would be looking at not just a sort of copper retirement notice, but that's where the service discontinuance would come in. And so that whole question of making sure we execute properly our responsibility to oversee those kind of service discontinuances is really important. And that's why we wanted to start the process of identifying kind of the metrics that we would use in evaluating whether to allow an incumbent to stop offering service or to replace service. For example, a wireline with a wireless service like what was proposed in Fire Island. so that we have metrics on that. So that's the sort of issue on which comment would be really helpful, because we want to be sure that whatever replacement service is available is fulfilling the reasonable expectations of the community.
Great. Thank you. Let's see if we have one or two more questions.
I can mention one other thing. That's one area where also some of the trials that are being proposed, for example, AT&T's proposed trial, which they're going to submit a full formal application to us, we understand, the second half of 2015. Part of what they're looking at is this issue of wireline to wireless, and whether the wireless solution can meet the needs of the community. So that's another venue in which participation will be helpful.
Okay. All right, Matt. I think we could let you go at this time.
Okay.
And any
Great.
further questions, we'll get them to you, or also be sure to get them in the record as in the response to the notice of proposed rulemaking. Your comments in the record, they don't need to be elaborate. They don't need to hire expensive outside attorneys. They could be simple, 1 or 2 pages, if that's all you have to comment on. We just really would love to hear from states and localities and tribal nations. Thanks.
Thank you.
Okay, that concludes today's webinar, FCC state and local government webinar. We hope the topics have been of use to you, and we're trying to cater them to states and localities. Please let us know, let me know what other topics you might want to hear about, and we'll do our best. And also any other issues that come up for your jurisdictions that involve the commission, you can come through my office, the Office of Intergovernmental Affairs, and we'll work with the other offices and bureaus to get you an answer. Thank you. Have a good afternoon.